Look at this is Paul, retained by the people. Now, the people here must be used in the sense of we, the people. Yeah. In the preamble and in the 10th Amendment. Yeah. To illustrate the right of appeal upon the law and facts was given to the Supreme Court. It had been objected that this denied or disparaged the right of trial by jury as understood at common law. Hence the Sixth Amendment, Federalist number 83, and hence the declaration of the same principle in this amendment. Yeah. Now, we the people, yeah, known as the criminalized homeless people, yeah, that don't have any right to appeal, yeah, because of 1077s and 71s, yeah. Now, Article number 10, yeah, powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. Yeah. Now, the powers, yeah, of course, mean all those which had been committed to the different departments of the government. Yeah. Delegated to entrust, to commit, to deliver to another's care and exercise. Webster's Dictionary. Yeah. The successionists laid great stress upon the word delegate and attached to it the meaning that the states had. In fact, surrendered none of their sovereignty, but only created a common agency with certain powers in trust, which each state for itself had the right to resume at pleasure. The nor prohibited to the states could have little force with those holding such doctrines. It has been so fashionable to interpolate, yeah, expressly that many believe the participle delegated is so qualified, but such a qualification was moved in Congress and rejected. Lloyd's debates, McCulloch versus Maryland, Wheat, Martin versus Hunter, yeah, Wheat, Houston versus Moore, Wheat, Anderson versus Dunn, Wheat, Articles of Confederation, see Abelman versus Booth, Now, all powers not delegated, not expressly delegated, and not prohibited are reserved. Yes. Now, see United States versus Bailey. The same reservation in substance was contained in the second article of the Articles of Confederation, except that the word expressly was there placed before the word delegated. Metropolitan Bank versus Vine Dyke, yeah, and McCulloch versus Maryland. Um, they contain no inhibition upon Congress to legislate upon legal tenders. Yeah. Now, Article number 11. Yeah, this one was removed. Yeah, what caused this amendment? Yeah, and then what is now the rule? Now, this decision held that the original Constitution embraced suits by as well as against states. Yeah. So that now no suit lies by a citizen or alien against a state in the courts of the United States. Now, against one of the United States, what suits did the amendment include? The amendment only applies to original suits. Yeah. Does the suit apply to admiralty cases? Now, let's see here. This is kind of a big one, isn't it? Yeah. Now, the state is not party unless it appears on record as such. Yeah. As either plaintiff or defendant. Yeah. Article number 12. Yes. Probably the editor transferred to appropriate place. It does not disturb any arrangement in the original Connor's analysis. And see, and maybe it was 11. It could still be enforceable. Where a state sues in its own courts and obtains a judgment against a citizen, the defendant may prosecute a writ of error in the Supreme Court and test the constitutionality of state law. Yes, yes. I'd say I could get a writ of error. Yeah, considering the 1077s. Yeah, the 1071s. Yeah. You know, could you get me all the writs of error where I could sue the Washington State Supreme Court? Yeah. Now, fabricating of evidence. Yeah, hate crimes. You know, I'd like to use the Supreme Court of the state of Washington and for Justice Madsen. Yeah. Looney Tunes. Yeah. I told you never wanted to see me. Now you're going to. Yes. And Justice Wiggins. Yeah. You're not retiring. Ah! Justice Johnson. And Justice Yu. Justice Gonzalez. Yeah. And Justice Fairhurst. Yeah. You know, for all the justices of the Supreme Court of the state of Washington, I'm kind of thinking that it's a writ of error. Yeah. And that you will not be able to resign from the Supreme Court. Now, it sounds kind of like a weird lawsuit. Yeah. I'm suing for the inability of you to be removed. Yeah. As in, you no longer have the legal right to resign. Yeah. From being a justice of the Supreme Court. Now, you would say, what if I die? Obviously, that's not resignation. If you want to have a mental health evaluation and you're found insane, yeah, you could resign then. Yeah. If you have a mental or physical disability that no longer allows you to be a justice, yeah, you could resign then. But if you have no mental or physical disability, I'm going to sue right now. You can't resign. Now, you've been concealing felonies in the state of Washington. And the tens of thousands of emails that I sent to the Supreme Court of the state of Washington, yeah, you're not resigning. Yep, we're just stuck with you until you issue a writ of error. Yeah, and then when I get that writ of error, the 1077 for fabricated evidence, yes, both in Clallam and Jefferson County, and the 71s, yeah, for both Clallam and Jefferson County DMHPs, yeah. And then the mental health evaluations on the protection orders, yeah, for Clallam County, yeah, and the United Nations, yeah. And then for all of the times that you're right now, right? No, right